Court ruling in Consolidated Petition 5659 of 2019. On April 1st, 2019, the High Court in Nairobi made a ruling on an application by the Kenya Human Rights Commission, the Nubian Rights Forum, Kenya National Commission on Human Rights, which was supported by Muslims for Human Rights, Haki Center, Info Action, and the Law Society of Kenya. The conservatory order is aimed at stopping the rollout of the National Integrated Identity Management System, also known as NIMS. Conservatory orders are usually issued by court to prevent the application of a law on set of action before the court decides on a certain matter. The ruling on April 1st, 2019 by the High Court barred certain parts of NIMS rollout. It ruled that the government cannot collect doxybinocular DNA or global positioning system GPS coordinates from any person. The government cannot compel any person to register under NIMS. The government cannot issue a deadline for registration under NIMS. The government cannot tie access to government services to registration under NIMS. The government cannot share information collected under NIMS with any national or international organization. It is important to note that these orders are temporary, pending the final outcome of the case. We believe that the government should suspend NIMS and go back to the withdrawing board to deliver an identity management system that is safe and secure, that respects the rights to privacy and liberty, and that protects stateless and other marginalized communities from further discrimination and deprivation of Kenyan citizenship.
We are receiving worrying reports about threats of the public for exercising their legal right to boycott this exercise. This is particularly worrying, seeing that the court ruled that the NIMS registration cannot be shared with any government or any other department. This is an unacceptable violation of the law and an open contempt of the orders issued on the 1st of April to the effect that every Kenyan has the legal right to boycott this exercise. Contrary to what the government continues to claim, this exercise is not mandatory. Every Kenyan has the discretion once again to boycott this process without any government retaliation. We are ready to institute contempt of court proceedings against any individual or entity that seeks to compel any person to register under NIMS. We urge Kenyans to opt out of this exercise. We remind Kenyans that they have the right to choose to opt out until such a time that the court will rule on its legality and constitutionality. No Kenyan should face retaliation from the state for opting out. We also call upon any person who has faced on any form of retaliation to reach out to us using our SMS hotline, which is number 22582, or contact us on our website or phone numbers. Over the past few weeks, Kenyans have voiced their skepticism and opposition to the NIMS rollout. The NIMS case seeks to determine whether the NIMS rollout will continue without strong and credible legal framework that protects the right to privacy and freedom from unwarranted mass surveillance, the right to information, and that addresses the legacy of deprivation of citizenship for marginalized communities such as stateless communities, communities living in northern Kenya, and communities living in border areas. These issues will be determined in due course. We must not allow NIMS to consolidate the flagrant violation of human rights and constitutional norms witnessed over the last 10 years, or the discrimination against marginalized and stateless communities witnessed since independence.
Before you today are strong supporters of human rights and development. We all support Kenyans' rights to access government services, not on account of possessing a Huduma number, but as an entitlement clearly outlined in the Constitution. The rationale and thinking behind NIMS leaves a lot of unanswered questions. We reiterate our call on the government to suspend the names rollout until we have credible and robust institutional and legal frameworks to safeguard it. Until such a time, we urge Kenyans to continue exercising their right to choose to opt out of this exercise. In the meantime, we will be serving all county governments and county commissioners with a copy of the orders issued by the High Court. We want all levels of government to be aware of their obligations under the law. We would like to reiterate that all options for pursuing and any individuals or entities that flout these court orders, including contempt of court proceedings, as well as filing complaints with the Ethics and Anti-Corruption Commission, are on the table. Thank you. We will now take questions.